possible to continue here. Is that for us, or do we do that? Yeah.
Well, welcome everybody to this, the second Al-Tamimi Hidden Risks in GCC Construction Contracts webinar series. I'm Andrew Sims. I'm the partner in charge of construction and infrastructure matters based in Doha. And today speaking together with myself are two of my colleagues in the Dubai office, Naif Yahia, who is the head of construction litigation, and then Patrick Dillon Malone, who is an Irish senior counsel, also based in Dubai and in our international litigation team. So next slide, please. So the issues today that we're going to be discussing are, as advertised, conditions precedent in construction contracts, and then secondly, in a slightly different format, and just to break it up and make it a little bit more interesting for all of you who are watching, a discussion between Patrick and myself, Patrick and Naif, with myself putting questions to them, which are generated by you. So please feel free as we proceed with the webinar today to put any questions into the chat box, and I will look to answer any of those that I can in relation to the conditions precedent section, and then I'll put those the questions in relation to bonds to Naif and Patrick as we go along. So as you can see, the process today, it's 45 to 60 minutes. We want it to be as best we can interactive through the medium of Zoom, but we've then got a purpose and approach, as we've stressed before, that this is really just to give something of a taster of the issues that we're sure you're encountering in your contracts and on site, and just to give you something of a steer for the purposes of asking the right questions and then hopefully getting the right answers. The reason why we call it hidden risks is actually because there are lots of assumptions being made by contractors, employers, subcontractors. And what we're trying to do in this series is to break through those assumptions so that you are better informed in relation to both the negotiation of your contracts and then secondly, insofar as you're signed up to a contract, understanding what it is that you've actually signed up to. So with no further ado, I'll proceed to the next slide and we'll start to discuss the concept of condition precedent clauses. So go to the next slide, please. So, as I'm sure many of you will be fully aware, what is it that we're actually talking about? Well, it's those clauses in your contracts which require a certain form of claim to be made within a certain time, and where there are statements within the contract that say that a failure to comply with that clause is fatal, potentially, to what would otherwise be a perfectly valid claim. Now, why are we calling it a hidden risk? Well, quite often what we find across the whole of the GCC, and it's not just the GCC, is that contractors and subcontractors in particular are often completely unaware that these sorts of clauses appear in their contracts. On the other side, from the employer's perspective, there is often a reliance on these clauses, knowing full well that they are in there, and then looking to avoid liability for what is in effect a technical failure by the contractor or subcontractor to rely on the clause, or to comply with the clause. And what we're looking to illustrate here is how both of those approaches, both from the contractor, subcontractor side and from the employer side, may well give you a problem which you hadn't necessarily expected. So what you can see there is an absolutely typical condition precedent clause. It's from the FIDIC Red Book contract, subclause 20.1. And I've underlined there what the consequences are that we're talking about. So in the first paragraph, shall not be entitled to additional payment. The second paragraph is a little bit more lenient, but nevertheless, as you can see in the final underlined section, that actually that leniency is tempered by saying that unless a claim has already been excluded by the preceding paragraph. So that's pretty draconian. So next slide, please. Now, of course, the FIDIC drafting is actually coming from what is in effect the common law interpretation. Now, I have practiced both in the UK and then in Australia and Hong Kong. When I left Australia and went back to the UK, it was very apparent that there was still some divergence of opinion within the English courts about how these sorts of clauses were going to be interpreted. But over the last decade or so, there is no question, and you can see from the quotes from those two cases, that simply there is much more of a willingness to enforce these sorts of provision for the two reasons, particularly, both of which are related to certainty. Firstly, if you've signed up to a contract that says that you've got to do this, well, the common law position is pretty much now, then you better comply with it. Secondly, as the second quote shows, is that there is a very, very real purpose behind these clauses, and that is to bring to the notice of the employer or contractor, whichever part of the contractual chain you're in, bring to the notice of the other party that there is something happening on site which you think will require an extension of time or money, or both. Next slide, please. So that position has to be contrasted then with the civil law approach. Now, the short point is, and it's underlined there, is that it may be that there is a difference. And that is what I'll be going on to. But the starting position in front of the civil law is not dissimilar, in that basically what the civil law is saying is that the parties are free to choose what is in their contract, and insofar as they choose to include provisions which require compliance with a particular procedure, well, the starting position is that the law will enforce that. And we've set out there both the UAE position and the position in Qatar. Next slide, please. However, in contrast perhaps to the common law position, there are certainly several themes within the civil law tradition which can mean that those clauses are capable of being analysed and indeed overturned, insofar as there is certain behaviours by the parties which the courts don't feel are appropriate. And so an example there, which is from the UAE, is the unlawful exercise of rights. And the point that I'm looking to identify particularly there is a paragraph C, which is if the interests desired are disproportionate to the harm that will be suffered by others. So within the UAE Civil Code, what we have is a reference to something which is very similar to the quote that I had from the multiplex matter. And that is that there is a purpose behind these clauses, but insofar as a contractor fails to comply and the impact on the employer is relatively modest because they weren't given the notice that they wanted, the Civil Code, Article 106, may well step in and say it's disproportionate. Next slide, please. The next theme, and of course it's very much linked to the previous one, is a question of unjust enrichment. And simply what the civil codes are saying is that it is, in a sense, contrary to concepts of fairness and public policy, that an employer should be in a position where they have acquired the benefit of the performance by the contractor, for them to then turn around and say that on a technical basis, there's a failure to comply with the procedure. We'll have the extra work that's being done. We'll have the performance. We'll take the liquidated damages and not pay or grant an extension of time. And so what both employers have to be aware of is that if they're coming from the perspective of the clause in the contract, and maybe from a common law perspective, that actually the UAE and Qatar courts and the other courts in the GCC region would be extremely reluctant to enforce a clause which is effectively a technical clause, a technical compliance clause, leaving the employer with a benefit which they haven't paid for. Next slide, please. The third theme is one in relation to good faith and/or an abuse of rights, and I raise this particularly in the context of Qatar, where this is frequently used as a basis for avoiding the implications of a condition precedent clause. And obviously, what you often have in these situations is where something is happening on site and it is obvious to everybody on site that there is an impact on progress because of a reason which gives the contractor an entitlement to, for example, an extension of time and money. And what the principles of good faith and abuse of rights are saying is that simply, if you do know about it, yet you as the employer still turn around and rely upon the technical breach of the procedural alignment, then principles of Sharia law will apply such that the claim may well survive. And this then adds a whole level of to a certain degree, uncertainty, but nevertheless, it is an uncertainty that you need to be aware of from both sides of the fence, whether it's as an employer or as a contractor, that actually the clause may be capable of being challenged. Next slide, please. And then the final aspect, and this links very much to the aspect of liquidated damages and the question of the employer being in a position to take liquidated damages when in fact there is no real basis for it. The Articles 171, 172 of the Qatar Civil Code are identifying that the Qatar courts will look behind what has occurred on site, and especially if there might arguably be no loss resulting to the employer, then the courts would be reluctant to uphold the clause. The courts will retain a discretion to amend the compensation to actually reflect the actual loss. And as some of you will know, this sort of issue arises generally in relation to liquidated damages provisions, where all of the GCC jurisdictions will allow for a liquidated damages figure to be interrogated by the courts. Invariably, that is to revise the liquidated damages figure down. There's some argument, certainly in the UAE, that maybe that figure might be revised up. But of course, that is a potential challenge on a liquidated damages figure, which is in large part simply not available in common law. And you can see that same thread of jurisprudence coming through from the civil codes into the way in which condition precedent clauses are interpreted. And the final point I just wanted to make in relation to GCC laws, next slide please, relates to mandatory limitation periods. Now, there is undoubtedly some confusion in the interpretation of what is actually meant here. Certainly from a common law perspective, the issue to do with limitation periods relates to the expiry of a claim over a period of time. In the most common law jurisdictions, it's something like 6 years or 12 years if a document's executed as a deed. In some places, it might be even longer. I know in Western Australia, it certainly used to be something in the order of 20 years. In the GCC, it's linked also to issues to do with decennial liability. But the statutory limitation periods in most GCC countries, and particularly Qatar and UAE for these purposes, is fixed by law. And it's not possible in your contract to change that. However, the question where there is some confusion is whether or not those provisions, and there are differences between the UAE and Qatar, they're not exactly the same by any means, but the question is whether or not that those provisions relating to statutory limitation periods also apply to notice procedures in respect of bringing claims. Certainly it is something that we have used here in Qatar to challenge a basis on which our contractor clients' claims have been rejected. And it has been successful. But again, I just wanted to emphasize that within the GCC countries, there are a number of different bases on which the condition precedent clauses could be challenged. And this one in relation to 418 of the Qatar Civil Code and 487 of the UAE Civil Code are very much there in the background. Next slide, please. Just before concluding on this then, I did just want to highlight to you that obviously maybe certain themes have come out from FIDIC in relation to clause 20.1, which I mentioned right at the very beginning. And certainly in various discussions that I've had across the region, one with the Chartered Institute of Arbitrators in Egypt, there is a sense that for too long, parties have been including these condition precedent clauses in their contracts. And really, what do they actually achieve? Invariably, there is a lot of dispute over them. And might it be better in some way that we dispensed with them in their entirety? Certainly, as this clause from the FIDIC Gold Book suggests, there is perhaps a melting of the otherwise fairly robust position at FIDIC, which is where what they're saying is that, and maybe this comes back to the themes in the GCC, that insofar as no prejudice has actually been suffered by the party that is relying upon the condition precedent clause, then perhaps they ought not to be able to rely upon it. So the final slide, just some conclusions. And there's a sort of expectation that maybe there's going to be a massive difference between the GCC and common law. But the short point, and I hope it's clear from what I've just said in relation to both traditions, is that both legal systems will look to try and deal with injustice in some way or other. And that may come through the way in which the condition precedent clauses are interpreted. So in the common law, the assumption has to be that condition precedents are likely to be upheld. And insofar as, for example, English law is selected for your contract in the GCC, you need to be ready for that rather more robust and draconian approach. It provides significant certainty. The point that I make about the parties relying on clauses need to be consistent is that there is also a theme in English law, which is that you can't have it both ways. if you're going to be relying on that sort of clause, then you need to have been following the procedure as well. And that is something that employers are not always alert to. You can't really turn around at the end of the contract and start claiming that the other parties failed to comply with the procedures if you yourself has not been complying with them. And that final point is reliance on the exact compliance is dangerous. Then from a civil law position, the primary point is that the parties are bound by their contract. However, there is undoubtedly much more room for arguing breach of good faith, unjust enrichment, and the potential for a penalty. So the solution, though, as I say there, is to the best of your ability, find out what the procedures are in your contract, whether you're the employer, whether you're the contractor, and follow them. That is bound to be the easiest way of making sure that, firstly, both parties know what's going on site, that it's properly documented, and that the proper entitlements within the contract are granted at some point. Now, that's me finished on the first section. I was just going to invite Naif, and indeed Patrick, if you wanted to make any sort of comments, or then we can move straight on to the bonds discussion.
Thank you, Andrew. Just a couple of points with respect to the first part of the session. Just a common question that I've always received from clients about the notice requirement under FEDIC. Is it a time bar or not? It's a point that you addressed in your couple of slides back. But from local law perspective, from civil law perspective, I just wanted to add that, to me, I cannot consider it as a time bar. I have not seen any judgment in the UAE considering the notice requirement as a time bar provision or amending the time bar under the law. Therefore, our position that the notice requirement under FEDIC or any other form of contract should not be considered as time bar, but we've seen a lot of contractors defending their position by trying to say that the time bar provision, or you're trying to amend the time bar provision under the contract, and that's not permissible under the laws, and trying to avoid the procedures of the contract. But in any event, that said, as Andrew said at the end of his slides, you need to follow the process. You need to follow the mechanism that agreed between the parties. Despite whether or not you're in front of arbitral tribunal or local courts, it always helps the lawyer to have a strong case with if the contractor follow the process. So that's the first point. The second point is the expert attitude that I see in courts. A lot of construction cases now have been referred to courts, including main contract disputes, unlike the past where most of the cases are referred to arbitration. Nowadays, or since the last 10 years, we've seen increased number of main contract disputes in front of local courts. And the experience of local courts and the local experts are getting better every day, obviously not only in the UAE, but also in Qatar and other GCC countries, due to a lot of number of cases that were heard by the local courts and experts and the experience they gained from looking at different types of disputes in the construction industry. But just to give you a flavor of the attitude of experts, I will use UAE as an example. They are very much more flexible than arbitral proceedings, where they kind of ignore sometimes the notice requirement. I'm not saying this is correct, but most of them ignore the notice requirement. But here I need to make a distinction between two types of claims. One, additional cost for variation. They are very flexible. If you have a variation order from the engineer or from the employer, where they will say that the engineer issued a variation, the contractor implemented the work or executed the work on site, therefore the cost should be recovered by the contractor, even if the contractor fails to follow the notice requirement. So that's on with respect to variation. So they are very more flexible. If you have strong evidence that there is a variation order, you have executed the work or the additional work on site. The other aspect is the extension of time. And here I make a distinction between two things. Extension of time claims for time, they are not very flexible. They are very flexible, but extension of time for prolongation costs, then they are not very flexible. So when you file for extension of time, even if you don't follow the notice requirement or the process under the contract, if the case went to the court, the experts tend to be more flexible to not to apply penalties. If there are reasons of delay, there are minutes of meetings where you recorded the events of delay, the cause of delay is the employer or authorities or the engineer, then they will tend to be more flexible with the contractor not to apply liquidated damages or penalties against the contractor. But when you try to recover prolongation costs, then it kind of be more problematic. And I'm just trying to give you practical tips of what's happening on the ground with the local courts. So just wanted to add these couple of points on the first part of the.
I think it's very clear, isn't it, that it's similar. The themes behind what you've just said, Naif, are very much those of the fact that the employer knows what has gone on when it's its reason for delay, and it has got the benefit of additional work, then the court experts are more prepared to recognise that there's an entitlement, irrespective of what the condition precedent clause says. Thank you.
I just have one question as well, a very short one, on the room for triviality in English law or in the common law position in this particular context, because in the common law courts will generally read contracts from a commercial perspective. And that leaves generally some room for triviality to come in. It's not quite a proportionality test, but do you believe that has room in the condition precedent context as well?
Yeah, I think that's good. In the common law context, that's got to be right. I mean, and it's back to my slide there. You know, the legal system is not looking is looking to give certainty, but it's not looking to penalise contractors and subcontractors where an effort has been made. Interestingly, yeah, I did have a quote from one of my favourite cases in relation to conditions precedents called the City Inns against Shepherd, where it was a Scottish matter, where one of the judges said that insofar as there is a condition precedent clause in the contract, it's not for the contractor just to ignore what's in there. But I think the corollary of that is that insofar as the contractor has tried to comply to some extent with both the period of time in which the claim needs to be brought and the level of detail, then no court, irrespective of the jurisdiction, is going to be looking to knock that out. And it's back to the point at the very end there. It's do your best to comply with it, because if you are seen to have been providing information as best you can, the likelihood of an arbitral tribunal or a court turning around and saying, you've done all this work, you have actually been delayed, but you're not going to get any time or money, is bound to be minimised. Okay, can we go to the next slide then and move on to the second section? So, the idea behind this, just to sort of break it up rather than listening to all of us just speak to a set of slides, is to perhaps we want to put some questions to Naif and Patrick, and some questions have been coming in. Let me I'll field these questions as they're coming. So So there's the first one that's come in, which is in relation to, so perhaps I'll move on to the next slide because that's got some of the themes. So, insofar as for example, a contractor, I mean, we've had exactly this query come in only yesterday on a live matter. Insofar as a contractor anticipates that a bond is going to be called, what would you suggest? Perhaps I'll put it to Knife first, and then to Patrick, as to which courts you could go to in order to try and secure some sort of injunction, or however we might call it, to stop the call on that bond, to stop the bank or financial institution paying out. Do you want to field that one first, Knife?
Yeah, thank you, Andrew. Yeah, that's an interesting question. We actually faced this recently kind of every day because of the liquidity situation following COVID-19 impact in the market, where we're seeing a lot of employers and main contractors trying to liquidate performance bonds and other types of bonds with the banks. And a lot of contractors come to us to try and stop the liquidation by way of an injunction. So the first question we ask ourselves, which forum or which court we should approach to try and obtain the injunction. And here we need to make a distinction between different contracts. For example, if you have agreed on arbitration, then the forum that you should approach, either emergency arbitration, which is in practice very difficult to happen because it's not really common in under all the institutional rules, and also it's very difficult to constitute a tribunal within a short time to try and get an injunction. But if you have an arbitration clause under your contract, then the jurisdiction lies, and it's not seated in the IFC, and I will leave Patrick to talk about this. For example, it's seated onshore Dubai or Abu Dhabi or any other places, then the competent court that you should approach to obtain an injunction is the Court of Appeal, where the seat of arbitration is located. So, for example, if you agreed on Dubai seated arbitration, onshore Dubai, then you should approach the Court of Appeal in Dubai to seek an injunction to stop the liquidation of the bond. If it's seated in DFC or EDGM, then the supervisory court is or are EDGM and DFC respectively, and therefore the supervisory court is the one who has exclusive jurisdiction to decide on the injunction of the liquidation of the bond. If there is no arbitration clause under the contract, then the automatic answer to this is that the jurisdiction lies with the summary judge of the place of residence of the defendant, which is the employer, and in case of the employer is the one who is calling the bond, and or the place of the issuance of the bond itself. For example, if the bank is located in Abu Dhabi, then you need to you have the choice to go to Abu Dhabi court or Dubai if the place of residence of the employer is Dubai. So these are the main issues that we look at when we decide on the forum before we apply for the injunction. Patrick?
Yes, very similarly.
Patrick, so just before you start, good. Maybe we could switch. We could switch just to the screen with you two on rather than the slides.
Thank you.
There we go.
Can you see us now? Yeah.
Yeah.
Very similarly, in the DIFC court, there's a specialist division, the Technology and Construction Division, which is very well equipped to respond to emergency applications for urgent interim relief. And the DIFC court, as an international commercial court, is very well used to acting swiftly in response to urgent applications. And it applies the English test as it has been adapted specifically to injunctions to constrain the call on bonds, which we'll come to, I think. But the point is, again, that emergency arbitrators are possible within the DIFC LCIA. Again, not a likely or realistic prospect when you're trying to stop an imminent call on a bond. So the DIFC court's jurisdiction can be triggered either, as Naif just mentioned, whether the bank, for example, might be located in the DIFC or might have a branch in the DIFC. The more usual way in which because construction contracts are physically in the DIFC are quite few. It usually arises by an opt-in clause, and in those circumstances, you can either go straight to the court for its freestanding interim jurisdiction, or quite often, in our experience over the last year or so, has been that this has been more often. The DIFC court's jurisdiction is because it is the supervisory court for a DIFC LCIA arbitration. And there, the court can either act as the enforcement court for an interim award already granted by an arbitration that's already up and running, or it can exercise its own freestanding interim relief in aid of the arbitration, which will be a future arbitration. So that's the way it arises, and we've had some interesting examples of that in the last couple of years, which I can talk about soon.
Yeah, just to add before you will continue the second question, Andrew, that if in case of agreement on arbitration and the tribunal is already constituted, then you can approach the tribunal directly to seek an injunction. And we've seen many examples in the past few years where the tribunal acted very quickly and issued interim injunction against the liquidation of the bonds in many big arbitrations in Dubai, Abu Dhabi, and other GCC countries.
Yeah. Thank you. Now, a couple of questions I'll put together. I think it's probably to you, Naif, rather than to Patrick, but maybe Patrick's got a contribution. Generally speaking, in the GCC, are the performance bonds that you see on demand or conditional? Is there a tendency one way or the other? And then in terms of the expiry period on these bonds, do they tend to finish at, well, we could call it practical completion, as opposed to final completion, which in many cases is at least a year after the main works are finished? So two parts: what's the nature of the bonds, and then secondly, how long do they last for?
Okay, thank you, Andrew. I think that from my experience in the past 15, 16 years in Dubai and in the GCC countries, most of the bonds, the employers tend to insist on unconditional and irrevocable bonds. Most of the cases, it's very limited time where I have seen a conditional bond in the GCC, but we've seen it, like some contractors who have special credentials insist on conditional bonds. We've seen it, especially in Dubai, because you know Dubai is the boom of the construction in the GCC. But 90% of the cases they are conditional bonds on demand, and therefore it's very limited time we see conditional bonds. In any event, on the other point, the issue of the expiry date of the bond, that's really important, and a very good question, Andrew, that it's very important to have an expiry date on the bond. Sometimes we don't see anything about expiry, which is very problematic, but a lot of cases I've seen where the expiry date is the date of the issuance of performance certificate, and we're talking about performance bonds. And in this case, unfortunately, it may not really help much, because if the employer is acting in bad faith, he will not issue the performance certificate. So this condition, or the expiry that you trigger from the date of the issuance of the performance certificate, is problematic, equally problematic than don't have any expiry. Why? Because the employer, if he wants to liquidate and if he's acting in bad faith, he will never issue, or he will instruct the engineer, although the engineer should act neutral, but sometimes it's not the case, where the engineer doesn't issue the performance certificate, and we end up with a bad expiry date. Mm-hmm. So it is important to have an expiry date that obviously you can renew based on the agreement between the employer and the contractor. But again, in practice, we've seen bonds, performance bonds with expiry date, but the employer threatened to liquidate before the expiry date. Otherwise, I will liquidate. They ask the contractor to renew, otherwise I will liquidate before the expiry date. Mm-hmm. So, I mean, in all events, if you have unconditional irrevocable bonds, the risk will always be there, unless the project was very smooth and no problems, which is very rare to see smooth projects in the construction industry.
Mm-hmm. Yes. Yeah. Just on expiry dates. Yeah, we had an interesting case in the DIFC court last year where the bank was in the middle. The bank was our client, and the bank hesitated because there was a condition, a precondition in the bond, and hesitated about whether that condition had been made. Now, obviously, this is one of those examples where the bank is conscious of its duty to its customer, conscious also of its duty to the beneficiary. But then the bond expired during that period of inquiry by the bank, and it led to onshore validity proceedings in relation to the validity of the call. And parallel to that, a case seeking a mandatory order from the DIFC court against the bank plus damages. So it was an interesting example. I know it's not really on the question of the type of bond, but again, a good example of how the expiry issue can come into play, and a very good illustration also of the position that the banks find themselves often in terms of where their duty lies and what their obligations are.
The next question I've got is it's a useful one. I think it relates actually. It relates to a slide that I know we've sort of produced already in anticipation of this possible question. And that is, what would be the procedure in front of the UAE court to obtain an injunction? And indeed, if you did manage to obtain one, what else would you be required to do? And there's a sort of mention in the question to do with this. I'm not completely familiar with it. It's very much Knife's area. Having to commence some other proceedings within a relatively short period of time. Could we have that slide up, please? The one with the diagram on it. It's the next slide, I think. I think that's right, isn't it, Knife? That's what would be.
Okay, thank you, Andrew. It's a very good question, and also a tricky one from local law perspective. Before I just explain the table that I produced, let me just answer Andrew's question briefly. The process is very simple. It's an ex parte application. Likewise, in common law courts, we have the right to apply to the summary judge. It's an ex parte, like you don't have to notify the defendant. And in this case, the defendant is not the bank, where in some common law jurisdictions, you need to join the bank in the proceedings. In local courts, in most of the Arab countries, we don't need to join the bank. It's an injunction, we call it an attachment order against the employer or the main contractor to stop the liquidation of the bond. And the order, let's call it an injunction order, is issued by the summary judge within 48 hours, sometimes even shorter if the time is pressing. So once we apply an ex parte application, we get the order within 48 hours. Then we communicate with the bank to stop the liquidation. The problem occurs when, if the contractor comes to us very late, we have to translate documents. We need to prepare the pleadings. That takes, I mean, obviously we have our team. In these cases, we dedicate emergency team to work 24/7 in order to prepare the translation, the documents in a very urgent basis, where we can turn around in 24 hours the application with the translation, depending on the volume of the documents, of course. But if you come to us earlier, that will really increase your chances to obtain an injunction against the liquidation of the bond if it's unlawful liquidation. But in general, that's the process. Obviously, the employer may appeal or file a grievance against the order, but obviously it depends on the evidence that the employer will use in such grievance or appeal. Just to explain the table quickly, the injunction of, normally I will use performance bond as an example, but obviously we have other types of bonds like the retention bond, the advance payment guarantee. The grounds for those bonds are different than the performance bond. To stop the liquidation of performance bond is slightly different than advance payment guarantee or retention guarantee. The evidence, we rely normally under the Civil Commercial Transactions Law, Article 417, which provides that the judge has the right to stop the liquidation of a performance bond or any types of bank guarantees if the applicant of the injunction application has a serious and exceptional grounds that the call is unlawful and there is an element of bad faith by the beneficiary of the bond. To do that, it's not easy. I have to be frank with you. We always say your chances of success for obtaining an injunction is 50-50. But you need to choose the right lawyer who has an experience on applying to the local courts or the arbitral tribunal or DFC court, who has previous experience in such cases to obtain an injunction against the liquidation. The evidence required that we normally need from contractors or subcontractors when they try to stop the liquidation of bonds, it varies from a project to another, but general guidance, we will have to ask for the amount owed to the contractor through payment certificates or any acknowledgement by the employer, where we can establish that the contractor actually is owed money by the employer, not the other way around. So it kind of shows that the employer is acting in bad faith, that he is liquidating the bond while he actually owes the contractor money, unpaid certified sums. So that's an important aspect that you need to consider when you compile the file to the lawyer who's applying for an injunction. Then other evidence that is also important, that the work is completed. Yes, it's very important to show the summary judge that the contractor completed the work, preferably on time, although obviously a lot of cases you will not be able to prove that you completed it on time, but at least to show us that you completed the work in order to increase your chances to stop the liquidation of the bond. What if the project or the liquidation happens during the execution of the work? Then we need to assess, is the contract terminated? If it's terminated, we have good ground to try and stop the liquidation of the bond, but depending on the surrounding facts of the termination. Is it breached by the contractor? Is it breached by the employer? Or is it termination for convenience? It will really depend, and it's a very complex legal issue that we need to assess on a case-by-case basis. So that's kind of a general overview of the evidence required from the contractor who wants to apply for an injunction to stop the liquidation of the bond. The last point, which is what Andrew asked about the requirements. What are the additional procedural requirements that you need once you obtain the injunction? If you are successful in obtaining the injunction from local courts, not DFC or arbitral tribunals, you need to file your substantive claim either through arbitration or local courts within 8 days maximum from the date of the order is issued, which means that you have a very tight timeline to prepare your main case or substantive case claims, your heads of claims within only 8 days. So that's why if you feel any suspicious that the employer or the main contractor is trying to liquidate the bond or has an intention to liquidate the bond, come to us as early as possible in order to try and follow the process, prepare for the heads of claims, prepare for the evidence that we need to submit. Although I can tell you that, yes, we can still do the job if you come late, because in many instances, I get calls from clients. Now, if they call the bond and I want to file a case, I say, why didn't you call me when they tried to call the bond in the first instance to try and stop them? But you need to know, even if it's unconditional bond, irrevocable, it's possible to obtain an injunction from local courts or arbitral tribunal if you agreed on UAE law. Just back to the 8 days requirement, the problem we face with the 8 days requirement is a tricky legal point about the escalation provision or the preconditions. Before you file your claims under the FIDIC contract and many other form of contracts, we have seen a very complex procedures or preconditions before you revert or refer the case to arbitration or local courts, where you have to either refer to the dispute adjudication boards, DAB, or sometimes obtain the determination by the engineer. So in this case, you will ask me how to file the substantive case while we only have 8 days and I cannot comply with the preconditions or the escalation provisions. It's problematic, but we have no choice. We have to file within 8 days. In the context of local court proceedings, what we normally do is that we file the substantive case, and local courts are more flexible when it comes to the preconditions, although it's kind of also problematic if you file without complying with the preconditions. But we find our ways in the local courts to try and overcome the hurdle of the preconditions. But if there is an arbitration, then it's more problematic because the jurisdiction of the tribunal is triggered after you comply with the escalation provision. But obviously, sometimes we find solution for clients, including asking the tribunal to suspend the proceedings until we comply with the preconditions. But it's a tricky point. It's not straightforward, and it has a kind of some downsides that obviously it has to be assessed on a case-by-case basis. Then, sorry, I took much longer than expected. Then we talk about the other solution. If you didn't manage to get an injunction and the employer managed to liquidate the bond, we still have other remedies, including the second part of the table. As you can see, I mentioned attachment application. Yes, it's not an application to stop the liquidation, but at least if you have payment certificates, use it after the liquidation to obtain an attachment order, or let's call it freezing order, against the assets of the employer, including bank accounts, the same bank account where the funds went from the bank to the employer, the funds of the bond went to the banks of the employer. Then you can apply for a freezing injunction or freezing order to freeze this account to make sure that the employer does not use the funds that he received from the bond. So that's another remedy that we normally use as a second remedy if we fail in obtaining an injunction against the liquidation of the bond. Evidence required is much easier than the injunction because you only need payment certificate or evidence that there is an amount owed, unlike the DFC court where for freezing orders you need to show dissipation of assets. But here in local courts, you just need to show that there is an amount owed acknowledged by the employer through payment certificates or even email where they are acknowledging a specific amount owed to the contractor. But again, the same requirement of 8 days applies with respect to the freezing order application that we filed in local courts. I think I've covered a lot of the questions. And
we go back to the, leave the slides and we go back to the full screen. Patrick, have you got any contribution to make on the,
yeah, well, maybe I can,
some similarities with the IFC?
Yeah, I can try and reflect that very briefly in the time. Just to sort of work backwards. Niall's quite right in saying that the remedy of impressing the funds that have already flown from the bank to the caller of the bond with a trust for the benefit of monies that are owed to you is trickier in the DIFC in the sense that under English law, because generally one must establish a risk of dissipation, which can be quite a high threshold. But if there has been evidence of lack of payment and of trickery, then that will go some way, and against perhaps a bad faith type sequence of events. With the DIFC, the procedure doesn't require any filing of substantive proceedings as such in that way. The claim form, of course, there are substantive proceedings that accompany. There's an underlying claim form, but it's a very simple document, so one doesn't have the same difficulty in applying for urgent relief before the DIFC court in having all one's ducks in a row and ready to go with your claim in the same way. The question of money being owed to you as a substantive defense is really the English and common law approach to that, is that really is not the type of consideration that is taken into account to justify or to ground a constraint on the call of the bond. If you're owed money, the principle is you resolve that later. The bond itself is unconditional, irrevocable, and if it's correctly called, then you sort out your differences later on when the count and reckoning is done after the fact. That's what the bond is for. And in England, in English law, as in DIFC law, there is a sort of starting point in common law cases, which is that these types of on-demand bonds are tantamount to cash. And that means that the test for granting an injunction in the DIFC is that, as under English law, is that there must be a strong case. And that means that there's an enhanced merits test. It's not just an arguable case, it's a strong case. And it must be positively established to a high degree of assurance that the beneficiary is not entitled to call on the bond. And so that is quite a high hurdle to pass. And like our onshore colleagues, we would obviously look very carefully and advise very carefully as to the prospects of success in any case. But we have had successes. And just to say, the way in which the English tests, I'll move now to the substantive test. I don't think we have time for the entire injunctive procedure, which will be familiar to most practitioners. But the test as it's applied, when can you stop the call of a bond in the English law, DIFC law approach? And there are really only two ways in which you can do that. The first is where there is an existing precondition. No, sorry, I'll say there's three. And I think there's probably only two in English law. And I think that as under Singapore law and some other common law jurisdictions, Australia as well, there are three circumstances in DIFC law, and I'll explain why. The first is where there's an express precondition that has been breached. A notice requirement or another formal requirement that has to be satisfied before the on-demand call is made. And those, as you outlined earlier, Andrew, there are good reasons to give force to those requirements because the courts recognize that they are there for a good reason. They allow for disagreements to be sorted out, and they allow for matters to be resolved. The case law to say that an implied obligation is just not going to do it. It has to be an absolutely express precondition. And equally, there's case law showing that a variation, especially a sort of informal variations to contract by reference to correspondence, again, that's not going to do it. It really has to be an express agreement of the parties demonstrating that this is a real precondition to the granting of the call. But where that is... You have
to give me the other two quite quickly because we're coming very close to the 60 minutes.
So that's number one, and we have had a couple of cases, both in an enforcement of DIFC LCIA interim awards on those grounds by the DIFC court, and also directly by way of a direct interim injunction, which have been, as the court has been satisfied that those express preconditions have been breached to the standard required at the interim stage. They've been satisfied. The second one is really where you've got no honest belief, and in English law that's confined to the fraud exception, where the rule is that there must be really the only realistic inference. The only realistic inference is that there has been fraud on the part of the beneficiary. In other words, they could not have had any honest belief, and the bank must have been aware of that circumstance. So it's a double test, and it's very strict. But the saving thing on this is that in DIFC law, there are principles of good faith that come in through the DIFC contract law. There are examples of the DIFC court and the Dubai World Tribunal applying good faith standards in this context, and including when applying UAE law, but also in DIFC law. And I think it's probably fair to say, even though there are no clear judgments on it, that a test of unconscionability, like in Singapore and like in Australia and some other common law jurisdictions, is probably enough to demonstrate a lack of honest belief in DIFC law, unlike in English law. And that gives rise to some interesting possibilities, because once one is talking about unconscionability, it is a much more fluid standard and a more accessible target than demonstrating fraud. Okay.
Now we have had an awful lot of other questions come in, but we're at the end of our time. So what I'll conclude, I think, by saying what we may do is we'll capture the questions that have been asked, and then maybe look to answer those at the same time as we circulate the slides from today's presentation, together with some other supplementary slides in respect of some other aspects. So on that basis then, I'd like to say thank you to my two esteemed colleagues in Dubai. I'd like to thank all of the attendees for attending, and there will be a further webinar in this series, probably now, not until perhaps towards the end of the summer, but we'll keep you posted. And certainly if anybody has any ideas in relation to topics that they would particularly like to have Al-Tamimi's specialist construction team address, please let us know. You know how to contact us. So thank you again.
Just to add that perhaps there are many other topics that we may address and discuss as another panel in our next session, as Andrew mentioned, not only sharing the slides, but also we may continue discussing a couple of the issues that I think are very pressing that we wanted to cover in today's session, but unfortunately the time really passed, and therefore we will continue discussing these topics with you in our next session, hopefully soon in summer.
For sure.
Thank you for your time.
Okay. Thank you, everybody. Goodbye.
Thank you. Bye.